Welcome everyone to our AHLA podcast today on healthcare fraud enforcement settlements and some recent trends we're seeing in the industry. I'm Joe Wolfe. I am the chair of the Fraud and Abuse Practice Group. Our goals at AHLA's Fraud and Abuse Practice Group are to help you stay informed about fraud and abuse compliance issues and developments in enforcement activity. At this point, I want to give Crane Pomerantz an opportunity to introduce himself and his practice. And over the next 15 or so minutes, we'll be talking about recent trends in healthcare enforcement. Crane, go ahead.
Thanks, Joe. I'm really excited to be here and joining you today on this podcast. I am joining you from scorching Las Vegas, Nevada, where I'm a member in the international law firm of Hill. I am a litigator. I represent a full panoply of healthcare providers in the healthcare space. For 15 years, I was a federal prosecutor working in the U.S. Attorney's Office here in Nevada. I started my career at firms in Boston and Washington, D.C.
Great. Thanks, Crane. Thanks for that background. And I'm Joe Wolfe. Again, I chair the Fraud and Abuse Practice Group for the American Health Law Association. I'll be in this role for the next 3 years. Have been heavily involved in AHLA for the last 12 years or so. In my practice, I'm a shareholder with Hall Render. I lead our healthcare regulatory practice group. And my work is very focused on financial arrangements in the healthcare space, anti-kickback and Stark issues and how they impact and interact with the False Claims Act and compliance issues, and the whole life cycle of physician arrangements from the development through potential compliance issues and issues of defensibility. And again, really excited to be tackling recent healthcare fraud settlements. It actually ties into a publication that AHLA just released called the Healthcare Fraud Settlement Index. And that index is kind of gives some different cuts of recent fraud settlements broken out by entity, broken out by states where the fraud enforcement has occurred, and getting into some of the detail around the allegations involved, the types of damage figures, whether there's a corporate integrity agreement and so on, allowing you to drill down and take away from that perhaps the important trends you're seeing in some of the information related to those cases. So now on to the podcast. As Crane and I were preparing for this discussion, we did have a discussion of just generally what is fraud enforcement. What are we talking about when we discuss fraud in activities and fraud settlements? And in my experience and in my practice, that often, as I previewed before, we're talking about anti-kickback statute issues, where we're opening, whether taking a certain action opens yourself up to a potential False Claim Act action under Stark or kickback allegations. Of course, as we all know that fraud and fraud settlements are broader than that. But I think like an introductory question for Crane is, when you think about fraud settlements and the laws impacted by this area and what could trigger a potential false claim, fraud claim and fraud settlement, what do you view as the scope for that activity, Crane?
Joe, it's a really good question. And I think you sort of touched on the answer in your question when you noted that answering the question, what is a fraud claim, is an extremely broad question. In my mind, a fraud claim takes a number of forms. It can be an anti-kickback act enforcement action. It could be Stark. I think it also includes sort of bread and butter billing cases, billing for services not rendered, upcoding, things of that nature. And I think when you consider what a fraud case is, you also need to consider who the enforcement agency is. So I think we're talking about civil FCA, False Claims Act cases. I think we're talking about criminal prosecution. And I think we're talking about administrative cases brought by the OIG or other agencies, to say nothing of run-of-the-mill, air quotes, civil litigation.
Yeah, I think I appreciate that, Crane, and I agree. It is often much broader than those of us that focus on healthcare even are thinking about it. It can be so expansive. And here we're talking about what are some patterns we're seeing in settlements, and so we're talking about patterns related to a very broad category of potential potential issues. And so let's keep drilling down here. Crane, along the idea of what patterns are we seeing? As we were prepping, we were talking about maybe even the absence of patterns in some of these cases regarding areas of enforcement. Can you kind of elaborate on that idea? Are you seeing patterns, or is there an absence of patterns, or what do you think?
So, Joe, where I'd like to start is in February of 2023, DOJ issued a press release in which it summarized its False Claims Act enforcement efforts. And I went through that press release pretty closely. And what I learned is this, that settlements and judgments under the False Claims Act for fiscal year 2022 exceeded $2.2 billion. Now, there were some interesting tidbits in that press release. Of that 2.2 billion, 1.9 billion came from whistleblower cases, and 1.7 billion were in the healthcare space. So what I think that data tells us are a couple things. First, the number of FCA cases are increasing. The number of FCA cases attributable to whistleblowers is increasing, and the total settlements are increasing. I think what it also tells us, most importantly, is that whistleblower action are driving these False Claims Act settlements. And why I think that's important is I think there may be a general misconception in terms of how the U.S. Attorney's Office makes a decision to pursue a False Claims Act case. It's unique to the case that comes in. So as we know, there is a process. Notification has to be given to the U.S. Attorney and the Attorney General. But it's very much an ad hoc process. A disclosure statement is made, a proposed complaint is submitted, and then an individual AUSA in the civil division of his or her U.S. Attorney's Office is making a decision whether to intervene and whether to pursue this case. To say that that's being driven by some sort of overarching policy or strategic initiative, I just don't think that's the case. I really think this is the civil division in each individual U.S. Attorney's Office making a decision whether to accept a case based on the merits of that case. Is it a case they can prove? Is what the relator is alleging, is that provable? And I think that's backed up by the information in the settlement index that you referenced. What I see when I use the index, which is a terrific resource, for example, I see a settlement with a substance abuse treatment center in the Southern District of New York. I see a settlement with a home health care provider in the Southern District of Ohio. I see a settlement with a nationwide specialty pharmacy in the Middle District of Florida. I see a settlement with the owner of a skilled nursing facility in the Southern District of Indiana. And so what that sort of does, Joe, is it confirms for me that there really is no pattern in terms of the types of FCA cases that the U.S. Attorney's offices are pursuing. It's not to say that the OIG or specific agencies don't have their initiatives. But in my opinion, anyway, the key TAM process is so idiosyncratic to the relator, to the plaintiff, to the person bringing the case. I just don't think you see strictly discernible patterns in terms of the types of cases.
Yeah, thanks for that response. Yeah, I mean, and you and I talked about this in preparation, but it seems that the whistleblower KETAM act sort of gets in motion, and then all the that's once in motion, it can be difficult to derail. And as we prep, we just talked about, what are some of the drivers of an FCA case? I think you touched on this already. The relator obviously is an important part of this, but are there any other key drivers you see with respect to these cases in the market when we talk about FCA settlements?
Well, I honestly believe that the key TAM process, to reiterate the phrase that I used earlier, is idiosyncratic to the plaintiff, to the relator. I think it's interesting to look at who are these relators? Who are the people that are generating these cases? And what you see without fail are disgruntled business partners, are employees who feel like they're not being treated respectfully. It's former spouses or former partners who have axes to grind. And so, it's really interesting when you look at these cases, the relators rarely tend to be just do-gooders looking to ferret out fraud. I think we'd all like to believe that's the case, and I'm not here to suggest that there aren't a subset of relators who really are offended by what they perceive as fraud. But what I think you usually see more often than not are relators that have some skin in the game one way or another. I hope that answers your question.
No, it does. I appreciate that. We, in preparation too for today's podcast, we talked about criminal pleas, and as you look at FCA settlements, what are you seeing with respect to trends on criminal pleas?
So again, using the AHL index as a resource, one of the things that jumped out to me was it was surprising how few of the FCA settlements are accompanied by criminal pleas. And I think this lends itself to a segue or a discussion into the Affordable Care Act, right? 2010, Congress passes the Affordable Care Act and amends the FCA to allow relators to use Anti-Kickback Act violations as a predicate for a False Claims Act case. And I would expect to see, since 2010, I would expect to see a number of False Claims Act cases that, in tandem, I would expect to see criminal pleas with False Claims Act settlement in tandem. And I sort of harken back to my own experience when I am defending putative defendants, healthcare providers, device manufacturers, pharmaceutical manufacturers, and we are notified that there is a potential pending false claims action, and my client is faced with a False Claims Act prosecution. One of the first questions we have to ask is there a parallel criminal investigation? And sometimes the USAO we're dealing with, the United States Attorney's Office we're dealing with, is candid. But most times what we're greeted with is no comment, or we can't comment on pending criminal investigations, or I'm happy to put you in touch with somebody in the criminal division. And there's a reason for that. The civil AUSAs have been trained really well not to leverage the criminal process, right, in achieving a civil settlement. However, it's not real helpful to defense counsel because whether there's a pending criminal investigation has dramatic impact on the strategic advice we give our clients. And so the possibility of a criminal prosecution is oftentimes used as sort of an invisible prod to spur settlement. Now, I have a somewhat cynical view, Joe, about the way some of the U.S. attorney's offices go about proceeding with their False Claims Act cases. And I'm going to use a sort of a loaded term, and I mean no disrespect to my former colleagues at DOJ, but sometimes the way the offices pursue the False Claims Act violations feels a little like illegal extortion, in the sense that what we hear is, you have no obligation to settle, of course, but you're looking at treble damages, you're looking at civil monetary penalties, who knows what's going to happen with exclusion issues. And so our goal is for our clients to avoid criminal exposure at all costs, especially for publicly traded companies. And it pushes us towards civil settlement most times. And when I see the absence, to bring this full circle now, when I see the absence of criminal pleas with FCA settlements, it sort of confirms my perception that the U.S. attorney's offices are using the prospect of criminal prosecution as a how do I say, as a cudgel, as a tool, I'll be polite about it, as a tool to achieve a civil settlement.
Great. Yeah. And thanks, Crane. I just have one final question. We do know of the hammer of the reverse false claims approach. In those cases, where their liability can attach when a party knowingly conceals or fails to return an overpayment to the government. What are you seeing with respect to reverse false claims? What kind of trends are you seeing?
Joe, when again, relying on AHLA's index, the index doesn't seem to show a lot of reverse false claims cases. Now, why is that important? I'm sure you've been in this position, and if you disagree with me, let me know. But I think the hardest advice I have to give clients on a consistent basis surrounds the issue of self-reporting. We've all been in the situation where a client comes to us and says, we've identified a problem. Bills have gone out improperly. And this dates back several years, and we've already been paid on these claims. And we want to be responsible about it, but we're really not sure what to do about it. And you have this calculus of, should my advice be self-report, or should my advice be, this is a business decision? I guess on some level, it's always a business decision by the client. But when I see, right, we have an obligation to advise our clients that retaining funds that are improperly paid is a violation of the False Claims Act. It's a reverse false claim, or arguably, assuming proper mens rea accompanies it. When I see through the index the lack of reverse false claims cases, it makes me wonder, and I ask this question rhetorically, maybe the best advice based on what we're seeing is to do nothing. At the end of the day, we can't lose sight of the fact that our clients are in business. Some of us represent nonprofits, but the overwhelming majority are in business to make money. And when a larger entity identifies a billing problem, and that problem can be 6 figures, 7 figures, what have you, making the decision to sort of self-disclose is one that has a huge financial impact. And I just thought it was interesting how few reverse false claims act cases I saw in the index.
Yeah, I think that I had a similar observation when I looked at the book. that is as you're alluding to, it's a challenging position to be in for our clients. Of course, we're scouring for any plausible argument to try to have a rationale as to why we're in a defensible position, and the decisions whether to self-disclose and how to approach a decision to self-disclose are complex as you're describing. What is the potential risk under a false claims analysis? What is the potential exposure under a whistleblower scenario and the treble damages and so on? And so I agree that I think that is an important consideration, given that there seems to be an absence of that reverse false claims activity. On that, Crane, I mean, thanks so much for your answers to these questions, and especially, and thanks to AHLA for putting together this index resource. I think that it is very helpful to see the cases being sorted in some different ways based on the type of allegation, based on the type of entity, to see that in a few different ways. It can be really helpful. Crane, before we wrap up here, did you have any final thoughts for the audience, again, on trends with respect to FCA settlements?
Joe, I'm really appreciative of the opportunity to speak with you today. Thank you for moderating this. And I look forward to speaking with you in the future, but I'm really appreciative of the opportunity to have joined the podcast today.
Great. Thanks to everyone within AHLA or outside of AHLA that's listening to this podcast. Please reach out to me or Crane if you have any questions on the content we stepped through today. We are developing a number of webinars and podcasts that will be rolling out over the next few months. I have a webinar coming up in just a few weeks on the super value case, so watch for that. We recorded a podcast on that recently. If you're interested in getting involved with our fraud and abuse practice group or with AHLA, please reach out. My email is jwolfe, JWOLFE @hallrender.com, and I'd be happy to help connect you up with an opportunity. We're always looking for more voices to step through some difficult issues. And thanks again, Crane, for being part of today's podcast, and thanks to AHLA for the opportunity, and also for putting together the healthcare fraud settlement index that we referenced today. It's a great tool, and I was impressed by the level of diligence that went into compiling all that information. So take care, Crane, and to everyone listening in, have a great day.